Hi, good afternoon, everyone. My name is David Carter. I'm a partner here at Womble Bond Dickinson and like to thank you for joining our webinar presentation today, What Companies Affected by the TCPA Should Know About This Year's Supreme Court Term. I'm joined in today's presentation by my colleague and partner, Artine Betpera, from our Irvine office, as well as an associate in our TCPA Defense Force group, Nicole Sue. Thanks again to everyone for joining us. This year's Supreme Court term is quite unique because the issue of the TCPA was clearly on the docket and part of the issues that the Supreme Court was considering. In reality, though, the decisions that we're going to focus on today address a larger interplay between the federal courts and federal administrative agencies that enforce and adopt regulations. In particular, to understand the discussion of the two cases that we'll dive into momentarily, you should understand a little bit of background about three specific doctrines that relate to deference between courts and federal agencies. The first is the Hobbs Act. Now, the Hobbs Act is actually a federal statute that was adopted by Congress, and in that respect, it is unique from the other two deference doctrines that we'll discuss. The Hobbs Act specifically vests within federal courts exclusive jurisdiction to enjoin, set aside, suspend, or determine the validity of certain FCC orders, which means then that a party that does not participate in bringing a challenge to an FCC order would be potentially stopped from challenging the validity of that order in subsequent litigation when they're, for example, sued for potential violation of the TCPA. So again, the issue with the Hobbs Act is that it provides a 60-day limitation period once the FCC adopts a new rule or order for parties to challenge that. And so if you don't participate in that 60-day window and bring your claim to the Court of Appeals, and years later are then sued for a potential violation of the TCPA, it creates a question of whether or not, as a litigant, you can raise challenges to the FCC's determination. The second doctrine is the well-known Chevron deference doctrine that has been in effect since 1984 under its current iteration. The Chevron deference doctrine essentially says that when it comes to interpreting the statutes passed by Congress, that courts should defer to reasonable interpretation of those statutes that are adopted by administrative agencies. So again, the focus is on whether or not the administrative agency has adopted a reasonable interpretation of a vague statute. If so, the Chevron deference doctrine generally says you should defer as a court to that interpretation. The final doctrine that you should be aware of is Auer Deference, also formally referred to as Seminole Rock Deference. This is another judicially made deference doctrine that basically says that a court should defer to an agency's interpretation of that agency's own regulations. So, for example, if the Federal Communications Commission adopts a regulation to interpret and enforce the TCPA, a federal court would defer to that interpretation of the regulation if it was a reasonable interpretation. There are several, again, pieces and issues about these doctrines and how they are applied that are at issue in the cases that we're going to discuss today. But as an overarching, again, big picture view of these, we're really looking at the question of whether federal courts will continue to defer to agency interpretations of federal law, or whether courts will play a more active role in determining the best interpretation of the law, giving less deference to those agencies, including the Federal Communications Commission. And as a general matter, over the course now of many years, dating back particularly to the late Justice Scalia, there has been an effort among some conservative scholars and justices to try to move away from a place in which federal agencies are given significant deference in interpreting laws and regulations and empowering the courts to be more active in that space. In addition, there is a notion that given the agencies less deference, will actually encourage the agencies to adopt rules and regulations that are more clear and more precise, and therefore help regulated companies understand what their legal requirements are from the beginning, versus being surprised or shocked to learn many years later that the agency that's regulating them is going to determine that they've actually been in violation of those rules and regulations because they're adopting a new interpretation. So those are kind of the battle lines that are being drawn in this debate. And as we wrap up our discussion at the end of the day, we will talk about how this, again, may play out specifically with regard to litigation concerning the Telephone Consumer Protection Act. So again, thank you for joining us. And at this point, I would turn it over to my colleague, Nicole, who is going to give us our first discussion with regard to the case PDR Network, LLC, and she'll tell us a little bit about the background of this case. Nicole?
Thank you, David. So the first case that we're going to discuss is PDR Network. Next slide, please. This case arises from a junk fax TCPA case. So PDR Network produces a reference book called Physician's Desk Reference, which contains information about prescription drugs. PDR sent Carlton and Harris a fax offering a free e-version of this desk reference. Carlton apparently doesn't like free things, so it immediately turned around and sued PDR Network for violation of the TCPA, claiming that the fax was an unsolicited advertisement sent without its consent. So the district court for the Southern District of West Virginia dismissed the case, finding that the fax was not an unsolicited advertisement because it didn't have a commercial aim. Specifically, PDR wasn't trying to sell the ebook or the prescription drugs contained in the ebook, so the fax had a missing element of an advertisement. Now, Carlton urged the court to follow a 2006 FCC ruling where the agency concluded that fax messages that promoted goods and services, even for no cost, are still unsolicited advertisement under the TCPA. The court found that it wasn't bound by the 2006 FCC order under the Hobbs Act because, as David mentioned, the Hobbs Act vested exclusive jurisdiction in federal courts to determine the validity of an FCC interpretation, and because there was no challenge to the validity of the FCC order being made in this case, the Hobbs Act didn't apply. The court also found that it was not required to automatically defer to the FCC's interpretation under Chevron deference because the definition of unsolicited advertisement was clear and easy to apply, and because the statute was clear, the court found that it didn't have to defer to the FCC's interpretation. So Carlton was upset and was clearly still upset about receiving this free ebook, so then it appealed to the Fourth Circuit. The Fourth Circuit reversed. It found that the district court was required to follow the FCC's 2006 ruling under the Hobbs Act because, as I mentioned, the Act requires all challenges to the FCC ruling to be brought exclusively in the federal courts of appeal. And the district court's refusal to follow the FCC's ruling was essentially equivalent to considering the validity of the FCC's ruling, which it didn't have the jurisdiction to do under the Hobbs Act. And so that brings the case to the Supreme Court.
Thanks, Nicole. This is our team, Beth Para. I'll go ahead and kind of take the baton from there and walk everyone through what exactly the court did in its opinion. So walking back just a brief moment, after the Fourth Circuit issued its opinion, PDR applied for certiorari for the Supreme Court to consider the question, which was ultimately certified, of whether the Hobbs Act requires lower courts to simply follow and adhere to FCC rulings. So just last week, on June 20th, the court issued its opinion. And if we could advance the next slide here, I'll break down how the justices came out on this issue. Now, ultimately, I will preface this by saying that the opinion was somewhat anticlimactic in that the court ultimately punted on the issue. But before getting into the specifics on that, let me give you a breakdown of how all the justices lined up. And you can see kind of through this diagram, going back to David's comment about the conservative push on agency deference, that this is very much reflective of the camps that we have here and where the battle lines have been drawn. So the majority of the opinion was authored by Justice Breyer and joined by Justices Sotomayor, Roberts, Kagan, and the notorious RGB. And then we had a concurring opinion by Justices Kavanaugh, Alito, Thomas, and Gorsuch, with Thomas and Gorsuch also authoring a separate concurring opinion. Now, with respect to Kavanaugh's concurring opinion, I'm not on video phone, so you can't see me do this. I'm putting air quotes around the term concurring because he actually disagreed with the majority's opinion to punt on the issue. And we'll cover kind of Kavanaugh's concurring opinion because that is really, quite frankly, probably one of the more interesting aspects of the opinion in terms of how Kavanaugh laid out the roadmap as to why he believes that the Hobbs Act does not prohibit challenges in the lower courts to the validity of FCC rulings. But why don't we advance to the next slide, and we'll keep diving in here. So as mentioned, the question that was taken up on cert was whether the Hobbs Act required the district court in the case to accept the FCC's legal interpretation of the TCPA, in this case, its interpretation of what unsolicited advertisement means. And so the court was not able to decide the question because there were two, quote unquote, preliminary questions left unanswered. And so the net result was that the judgment of the Fourth Circuit was vacated and the case was remanded for further proceedings as to these two preliminary issues. So what are the two preliminary issues that the court needed to be answered? The first question is whether or not the 2006 FCC order is the equivalent of a, quote, legislative rule or an interpretive rule. And the second question is whether PDR had a prior and adequate opportunity to seek judicial review of the order. So why is that important, or why was that important in the court's eyes? Well, the reason that the first question was important was that if the rule was an interpretive rule, then it may, quote, not be binding on the district courts. And the court used the word may in describing the potential impact of the answer to this question because it was not actually determining at that point in time that the interpretive rule would not have binding effect in the lower courts, but at least it was a possibility in the court's mind that that could be the outcome, and so hence that issue needed to be resolved. And really the importance of the second issue is exactly the same, in that if there was no prior and adequate opportunity to seek judicial review, then the order may not be binding on the district court. So if we can just back up to the slide right before this, as between legislative and interpretive, thank you, rules. So let's talk a little bit about the distinction between a legislative rule and an interpretive rule. And this is to say that, quite honestly, this is probably going to be another rather nuanced question that is going to be brought back down to the Fourth Circuit. So when the Supreme Court teed up the concept of the FCC's order being a legislative rule versus an interpretive rule, it did cite the two different prior opinions that get into the contours of what each type of rule is. And so in Chrysler Corp v. Brown, the court examined what it means for a rule to be a legislative rule, and there isn't very much black and white guidance provided. Although the court did say that a legislative rule has, quote, substantive characteristics, meaning that it may affect individual rights and obligations. And it also noted that the legislative rule is going to be a product of procedural requirements to assure fairness and maturity in the consideration of the rule, which actually dovetails into the second question that the court wanted answered as to prior and adequate opportunity to review. So there is a link here in between the issue, the questions, particularly as it pertains to whether or not the rule is a legislative versus interpretive rule. Now, the question of whether or not the rule is interpretive gets a little bit muddier because according to the Supreme Court's opinion in Perez versus Mortgage Bankers Association, an interpretive rule, in contrast to a legislative rule, is one that's not a product of a procedural mechanism like a notice and comment period. But beyond that, the court really doesn't provide too much guidance, and it's one of these sorts of things that's in a gray area, which, according to the court, is the source of much, quote, scholarly and judicial debate. So in light of the fact that we're dealing with two rules that leave a lot of leeway for argument, it's difficult to say how this is going to play out when it goes back down to the Fourth Circuit in terms of how it's going to come out on the question of whether this is a legislative rule versus an interpretive rule. And so that brings us to the second question, which is the prior and adequate opportunity to assert a challenge. So what the Hobbs Act says, starting from the rule to preface this, is that the Hobbs Act provides that agency action is subject to judicial review in civil or criminal proceedings for judicial enforcement, i.e. lower court proceedings, except to the extent that a prior, adequate, and exclusive opportunity for judicial review is provided by law. So that begs the question of whether the 60-day period provided by the Hobbs Act to challenge an FCC order provides a prior and adequate opportunity for judicial review. If the answer is no, then the result may be that PDR is allowed to challenge the rule regardless of whether it's deemed a legislative rule or an interpretive rule. So we have kind of the interplay of two sorts of questions as to what is the nature of the rule, number one, and then the second question being more arising out of due process considerations in that did the litigant have the opportunity at some point in time to actually assert a challenge to that rule. So let's kind of, that being the lay of the land on the majority's opinion, really it was a punt, and it's left to be seen how this is all going to play out in the Fourth Circuit. But what was particularly interesting here was some of the quote-unquote concurring opinions by the conservative bloc of justices here. Now, Kavanaugh certainly is the most meaty of them, but I'll start by briefly going over the concurring opinion of Thomas and Gorsuch, where they basically said that they did not believe the court's ruling, the lower court's ruling, was something that determined the validity of the FCC rule. And they had reasoned that interpreting a statute does not determine the validity of an agency order interpreting or implementing the statute, and hence the Hobbs Act's exclusive jurisdiction rules, the 60-day challenge rules, really didn't apply to that particular circumstance. And so we'll leave that there. But what was really interesting is Kavanaugh's concurring opinion, and so which was joined as well by Thomas, Alito, and Gorsuch. So Kavanaugh took issue with the fact that the majority punted on the main question. He believed that there was enough there for the court to decide the question that it granted cert to decide, and he also was very convicted in his conclusion that the Hobbs Act does not bar a defendant in an enforcement action from arguing that the agency's interpretation of the statute is wrong. So there were a number of reasons that Kavanaugh provided for his conclusion, which if we advance to the next slide, we can see kind of broken down into, actually, let's go to the one after this one. Thank you. Three different kind of categories of reasons why Kavanaugh felt that the Hobbs Act did not apply what he termed to be an as-applied challenge the validity of the rule in an enforcement proceeding. So to preface this, Kavanaugh did draw a distinction between what the Hobbs Act afforded in the 60-day window to challenge a rule, and that vests jurisdiction exclusively in the courts of appeal for those challenges. He characterized that as a facial pre-enforcement challenge to the rule, as distinguished from what PDR did, which was an as-applied challenge to the validity of the rule in an actual enforcement action. And so there were, like I said, 3 different categories of reasons Kavanaugh provided, or at least we can bucket Kavanaugh's reasoning into 3 different categories. The first is congressional intent. What Kavanaugh did there was point to other statutes, like the Clean Water Act and others, that expressly prohibited lower court challenges to the validity of the agency's ruling, and he distinguished that from the Hobbs Act, which is really silent as to an express prohibition on these sorts of lower court challenges to the validity of the ruling. And what his reasoning there was he pointed to the other statutes like the Clean Water Act, the Clean Air Act, and said, look, if Congress wanted to eliminate the right to challenge the validity of agency orders in the lower court, it would have said so. And look, pointing back at those statutes, it has done so in other cases. So the conclusion there to be drawn is that because Congress was silent as to the Hobbs, the preclusion of lower court challenges to the validity of agency orders in the Hobbs Act, that means that Congress did not intend to preclude those challenges in the lower courts. And he said, in those situations, when it comes to the Hobbs Act and FCC orders, there should be a default rule, being that unless Congress expressly precludes that challenge, then the door should be left open to what he described as an as-applied challenge to the validity of the rule in enforcement proceedings. So that's category number 1. Category number 2 is practical consequences, right? And I think this really was very much a common sense approach to the question, particularly when you have the structure under the Hobbs Act of giving a limited 60-day window to challenge a ruling at the time it's made, right? And so it's like saying that it's like binding entities that weren't even in existence at the time, for instance, who never had an opportunity to challenge the ruling to that ruling, and essentially shutting down their voice in lower courts to raise a challenge where they really didn't have the opportunity to assert one previously. And in the words of Justice Kavanaugh, he said, quote, "It's unfair to expect potentially affected parties to predict the future." And then the latter category of reasons Kavanaugh provided for his concurring or his conclusion that lower court challenges are allowed under the Hobbs Act is under due process. And so Kavanaugh believed it was unfair to require every potential litigant who could be affected by the rule to chime in within 60 days. And he believed that raised significant questions under the Due Process Clause, which he opined could be avoided by adhering to the default rule that he proposed of permitting judicial review of agency legal interpretations in enforcement actions. And so it's interesting here because although Kavanaugh termed his opinion as a concurring opinion, he ultimately disagreed with what the majority decided to do. Obviously, he feels very strongly about his conclusion that as-applied challenges in the lower courts should be permitted under the Hobbs Act. And what he did was, in effect, provide a roadmap for litigants to use as this opinion percolates down through the lower courts in challenging the validity of ruling. So I think we can expect Kavanaugh's concurring opinion to be cited quite often when it comes to any litigant on either side challenging the validity of any FCC order in future litigation. So it'll be interesting to see how some of this plays out, but it was a pretty bold move on Kavanaugh's part. He's basically saying that, look, I'm going to author the opinion as I think it should have come out, and I'm just going to leave this here for all you future litigants and the court in the future. So that pretty much wraps the overview of the PDR opinion. And so we can go ahead and now turn it over to the other important deference opinion from this term.
Great. Artine, thank you for that. And Nicole, before we move on, I just want to offer a few comments and observations here. Judge Kavanaugh, in issuing a concurring in the judgment opinion, essentially said it is right and proper for the Supreme Court to reverse and vacate the Fourth Circuit's decision and make the Fourth Circuit take a second look at this issue. And so as Artine articulated, he's essentially laying out a roadmap for how he believes the Fourth Circuit should analyze the issue when the case goes back in front of it, and then frankly inviting other courts across the country to similarly adopt a much more rigorous approach to the Hobbs Act than has maybe been in the past. As someone that's litigated a lot of telecommunications cases and not just TCPA telecom cases, I will tell you that this is an area of law that has been, I think, underdeveloped for quite some time, that many judges feel as though anything that touches on telecom, they simply have to accept what the FCC said and can't really look at the plain language of the statute or the language of the regulation that was adopted and really ask detailed questions about whether the FCC's conclusions are in fact proper and should be binding on parties. And I think that the important point in this particular context of the Telephone Consumer Protection Act that has to be kept in mind, and frankly, I'm surprised it hasn't gotten more airtime through the briefing and the oral arguments on this case, is that when the Hobbs Act was first adopted, it was adopted close in time to the Communications Act of 1934, when AT&T was the sole provider of telecommunications services. And while there were some other sort of providers of other services that were regulated by the FCC's mandate was extremely limited when you compare and contrast it to what the FCC does today. And for a statute like the Telephone Consumer Protection Act, which literally reaches and impacts millions of companies across the country when they communicate with their consumers, it is not practical or possible, frankly, for all of those companies to monitor every single development that happens at the FCC and predict, as Judge Kavanaugh says, what the future may hold for them and their company. And that does not consider or take into account those companies that didn't even exist when the FCC adopted a particular rule like the unsolicited facts rule of 2006. So if you're talking about a litigant that is being sued and someone is relying on the FCC's 2006 decision and the company didn't even exist at that time, it does seem to present some really significant questions about whether it is appropriate under due process and just the rule of law to say that the company has waived and forever abandoned their right to challenge the FCC's determinations. And the alternative process, which would I guess believe that the company could go back to the FCC and petition for a new rulemaking or start a new process to try to overturn the agency's decision, doesn't seem practical when you're in the middle of a case in which someone is suing you for millions, if not hundreds of millions of dollars for a potential TCPA violation, knowing how slowly, frankly, the regulatory rulemaking processes would occur at the FCC. I also think that there is an important point to understand about this distinction with regard to interpretive versus legislative rules, and the fact that, again, legislative rules being those that typically are adopted through a public notice and comment rulemaking period in which parties are invited to participate and give their views, and then interpretive rules, which more often are when the FCC is taking an enforcement action against a party or maybe makes a determination, write something in an order that's not actually part of the statutory, the regulations that they go on to adopt. So they're putting color on something. Again, I think that's an important consideration as well for courts when they're looking at whether a party should be able to challenge the FCC's determination. Clearly, a rule that the FCC has adopted through formal notice and comment rulemaking, it should get heightened deference because it is expected then that the FCC has carefully considered the viewpoints of different parties and different people and come out to a policy choice that they believe best meets the objectives of the statute. On the other hand, when they're writing an order that's maybe an enforcement order with one party, they're not getting the views of the different parties that are ultimately potentially regulated by that determination. So they're getting maybe the views of one or two isolated parties, but they're not going through the notice and comment rulemaking process and really soliciting a broad array of input to then achieve the best policy objective. Under those circumstances, you're really, in many instances, talking about the views of one or two staff people within a particular part of the FCC that has drafted the order. You're not talking about necessarily the views of the commissioners or those people that are charged with making policy. There's more nuances to that at the FCC, particularly about how certain rules get written and who is involved in that I think also has bearing if you were going to be litigating these issues. But at the end of the day, I think the takeaway for me on this particular case is while we don't have a definitive answer, what we do have, I believe, is an important discussion about when it is necessary and appropriate to defer to the FCC and when it is appropriate that litigants have the opportunity to voice concerns and raise issues that they practically could not have raised at the time the FCC made its initial determination. I think this is a long overdue discussion and one that's important, particularly for TCPA, but also for a broader array of agency actions, including the FCC and others. So with that, thank you again to Artine and Nicole for providing our overview of this discussion. And we're going to move into the next case, which is Kisor v. Wilkie. And there's probably not necessarily a lot of TCPA defendants attorneys talking about Kisor v. Wilkie because it doesn't have anything directly to do with the TCPA. But as I think you'll quickly learn, it has a lot to do ultimately, again, with how courts will view rules and regulations and orders issued by the FCC interpreting the TCPA in the future. So from that perspective, I think it holds equal weight to the PDR network if we're trying to look at and predict how litigation on the TCPA will unfold in the years to come. With that, I'm going to again ask Nicole if she wouldn't mind to give us our background on Kisor v. Wilkie.
Sure, thank you, David. So when the Supreme Court was summarizing the facts and background of this case, I want to read you a quote from the opinion. It says, quote, "Truth be told, nothing recounted in part has much bearing on the rest of our decision," end quote. So essentially, the facts of this case has absolutely no effect on the Supreme Court's opinion, but it does explain how the case got before the Supreme Court. So Kisor is a Vietnam War veteran who filed for benefits for PTSD with the Department of Veterans Affairs in 1982. That was when he was first. That was when he first applied, but he was denied at that time. He then sought to reopen his claim in 2006. And at that point, the VA agreed that Kisor suffered from PTSD, but only agreed to grant him benefits from the date that he reopened his case rather than award him retroactive benefits going back to 1982. So the Board of Veterans Appeals affirmed this decision based on its own interpretation of an agency rule. And under the VA regulations, Kisor could get retroactive benefits if the board found that there were, quote, relevant official service department records, end quote, that it had not considered in its initial denial. And the VA ultimately concluded, well, there were records that it didn't consider in its initial denial. These records weren't really relevant because it didn't affect the outcome of the case ultimately. And next slide. And so, as I mentioned, the Board of Veterans Appeals denied Mr. Kisor's claim. The Court of Appeals for Veterans Claims also affirmed the board's decision, and then it went up to the Federal Circuit Court, and they also affirmed the board's decision as well. And so that's where it gets us before the Supreme Court.
Great, thank you, Nicole. So this case, I'm going to walk you through the court's conclusions. Again, just as a brief reminder, what we're talking about in this case is Auer Deference or Seminole Rock Deference. And this is a judicially made doctrine in which courts conclude that when an agency adopts a regulation that is vague and then subsequently provides an interpretation of their own vague regulation, that the court should defer to the agency's interpretation unless it's plainly erroneous or inconsistent with what the agency, either the regulation itself, the interpretation doesn't fit the regulation, or there's something about the statute that prohibits that type of an interpretation. So again, we're talking about agency regulations and their interpretation. So the question presented in this case, which on its surface is about PTSD and veterans benefits, is really a fundamental question, again, about the way in which courts and agencies will interact and who has the ultimate say on what rules that are adopted by the agencies mean. So the question that was, for which the petition for cert was granted, is whether or not to overrule Auer and Seminole Rock deference and determine that those deference doctrines are no longer applicable. Much like our PDR network case, the decision comes out with a variety of different written opinions and a clear split between the four, which you would consider now, I believe, the four most conservative and the four most liberal justices, putting Chief Justice Roberts, in this case, as in many other cases this term, as the decisive vote. And to parse through the particular written opinions, it's more of a challenge perhaps in this case than in many cases, because Chief Justice Roberts essentially agrees with bits and pieces of the majority's decision while refusing to either expressly agree or disagree with other parts of it. So we have to then parse through which parts did he agree with and which parts does he not agree with. And then on the conservative side, we have two different opinions, the most substantive one of which is authored by Justice Gorsuch, who takes a significant aim at the majority opinion, but I think most particularly you can read through the tone and tenor of his opinion a significant angst with the Chief Justice, who had the opportunity to be the decisive vote and shut down this doctrine of Auer Deference that Justice Scalia and others have attacked now for many years. And as an interesting side note, it's somewhat important to appreciate that the irony of this is that the Auer decision that gave us Auer Deference was actually authored by Justice Scalia in the first instance. And then some years later, he began to say that he had made a terrible mistake and one that he deeply regretted, and he began to advocate for his own decision to be overturned. The advocacy that he led off with has since been picked up by our three most recent Supreme Court appointees, being Alito, Gorsuch, and Kavanaugh, who all as federal appellate judges had also authored opinions saying that they would like to see this doctrine done away with, but that at least at that time they were bound by it because they didn't have the authority to overturn it. So leading into their confirmations, it became fairly clear, and we've written extensively about the fact that this was going to be a potential target now that these justices were on the court. Frankly, though, I never expected it to be in their line of sight quite so quickly as it was to come up on this term already. Again, this issue, like the issue of Hobbs Act and its ultimate breadth and interpretation, is one that's not yet over, as I'll talk here in a moment. But I think it's important to understand the background and why this fight has been one that was taken on so quickly after we saw the confirmation of Justice Kavanaugh. So let's dive into the court's ruling. Again, the main part of the ruling is written by Justice Kagan, with Chief Justice Roberts joining in parts of it. So I'm going to talk briefly with you about the parts that he did sign on to, and then briefly with you about the parts he did not sign on to. So ultimately, the Chief Justice agrees with the liberal justices on a very brief background section that we've heard from Nicole, but then more substantively on Part 2B of the opinion, which the the majority opinion essentially goes out of its way to say Auer deference, when properly applied, is not as bad as everyone has been making it out to be. And indeed, they say that Auer deference is, in practice, properly quite limited and therefore should not give people significant concerns. As the opinion says, they restate and, quote, somewhat expand on the principles limiting Auer deference, but I think in practice, they've not somewhat expanded, but it's substantially expanded the limitations that courts will apply moving forward on Auer deference because, as I spoke earlier, it's been a somewhat reflexive application of the doctrine and not a very searching inquiry. I think now from this opinion, the courts will get the fact that they have to take a much more careful approach to the application of this doctrine. And indeed, we will see many, I believe, refusing to apply it moving forward based on the Gorsuch concurring opinion. So the issues now that a court must look at before they can apply the doctrine include whether or not the regulation in question is actually and genuinely ambiguous. And they must do that by carefully reading the words and applying traditional construction tools to try to first determine that it's not ambiguous at all. Second, they must ask whether the agency's reading, if it is in fact ambiguous, is reasonable, a reasonable one. That sounds very similar to how you would approach a Chevron doctrine application. But then they go on to say that a judge must also decide that deference to the agency is not appropriate if the agency is trying to get deference for something that's not an authoritative or official position, but maybe someone's merely wrote a speech or a letter that took this position, but if it's not the agency's position, then it's not entitled to deference. They also say that deference is not due if the agency is not applying its substantive expertise. So if the agency is trying to seek deference to an interpretation of a regulation about the Freedom of Information Act, for example, and they're the Federal Communications Commission, and their expertise is about telecom law, well, they don't really get to have deference on interpretations about the Freedom of Information Act because that's not within their area of expertise. Finally, deference would not be due if the agency's reading is not a fair and considered judgment. Again, the consideration or the rule here that the courts are trying to avoid is when they come and make up a determination basically at the time of litigation and they try to get deference for that determination, and that causes unfair surprise for the parties that are actually regulated. So at least some additional consideration will be paid to whether the rules are ambiguous, and if so, whether it's appropriate in that particular context to defer to the agency's consideration about the rule. Moving on, the Chief Justice signs on to a part of Justice Kagan's order that essentially says we will not overturn Auer deference because it's already decided. And so under the doctrine of stare decisis, the court is supposed to hesitate to overrule its prior opinions, even if it thinks the opinion may not have been that great or that even that good at moving forward. But unless there's some compelling reason, the Supreme Court typically decides to try to not overrule prior decisions in order to help create an environment in which law is more settled and less up and down and based on the whims of a particular judge at a particular time. Here, the majority opinion says essentially, look, Congress has known for a long period of time that we apply Auer deference in the context in which we apply it in. Congress has taken no action to stop us from applying it, which they fully could. They could, pass a law that says don't give deference in these situations, and Congress has not acted. So considering that there is another remedy through the path of Congress, then it's not appropriate for us here to overrule our own prior holdings. So they basically, again, 5 members of the court decide to keep Auer deference in place because they said it's already decided and we shouldn't revisit the issue. And then finally, with regard to the veteran that appealed, 5 members of the court agree that they're going to send the case back to the Federal Circuit where it originated from because they believe the Federal Circuit jumped the gun in declaring the regulation ambiguous and did not properly assess whether the interpretation should have received deference. So that's the meat of on the bones, and so to speak, in terms of what this opinion means moving forward. But I think it's equally important to understand where the Chief Justice departed from the liberal majority and refused to sign on to the opinion. And that is with regard particularly to Section 2A of the opinion, in which the majority asserts that Congress intended for agencies to be able to interpret their own ambiguous regulations and get deference for that the agencies have some unique expertise and apply scientific or technical terms, and that therefore necessitates deference to them, and that Auer deference promotes uniformity. So essentially, where the justices tried to argue that Auer deference was right and the right thing to do and is really actually positive and good, the Chief Justice declined to agree with them. So in this instance, you can say that Auer deference holds on and exists only because the Chief Justice agreed that stare decisis and not wanting to upset the apple cart that's already there, so to speak, was sufficient reason to keep it alive. But he didn't agree that it was necessarily a good law or that the doctrine was even should have been applied. He also did not sign on to a related part of the opinion, 3A, which argues that the Auer deference does not violate the Administrative Procedures Act, which, again, according to the liberal majority, giving deference to the agency's interpretation is appropriate, even though the Administrative Procedures Act says the courts will determine what regulations mean. They say that there isn't really a conflict between that, because all Auer deference does is tell courts how to determine what the regulations mean. It doesn't strip them of the authority to make that ultimate conclusion. Again, the Chief Justice doesn't agree with this analysis, suggesting that he believes there is a real tension between the doctrine, the deference doctrine, and then what the Administrative Procedures Act would require, which, as we'll see, the more conservative judges believe that the Administrative Procedures Act means the court really needs to be more empowered and should have less deference to the agencies. Chief Justice Roberts wrote a very brief concurring opinion, the thrust of which essentially is to suggest that there's not really that big of a gap between the opinion of the majority and that opinion of the conservative and authored by Justice Gorsuch, which we'll talk again about briefly. I think the important part here is you sort of see throughout this term in the opinions that the Chief Justice is authoring and where he's taking stands that are maybe inconsistent with the more conservative judges on the court, is he seems to be particularly focused on preserving a view that the court is independent of the political parties, that it's not just conservative versus liberal, and he's trying to do things that help retain the independent nature of the court. And so you can see through him weighing in on this case and basically keeping a doctrine alive that he may not agree with in principle, but nevertheless keeping it alive because of stare decisis, that he's more focused on that perhaps than some of the other judges at this point. So let us move into the concurring in the judgment opinion. Again, it's concurring in the judgment because the conservative justices are saying we agree with the notion that with the final outcome of the case, but just not the reasoning or how you got there. And so let us tell you the better reasoning, the better way to go about this. And this is where I think this is among, I would say, the more unusual opinions in the sharpness with which the dissents are written. It is very pointed and sort of very clearly demonstrates how displeased they are with the outcome here. The concurring opinion from Judge Gorsuch says that it should have been easy for the court to say goodbye to Auer deference, that the doctrine was invented by accident and without any meaningful effort to reconcile it with the Administrative Procedures Act. He says that the bare majority of the court flinches, which is clearly targeted at the Chief Justice, because he's the only one that could have potentially, quote unquote, flinched in this situation. And he goes on to say that the doctrine has been maimed and enfeebled and is zombified. So what are we really doing and why are we really trying to save it? Basically pointing out that by the time you apply all of the exceptions and the prerequisite steps before you get to Auer Deference now, under the majority's opinion, you have a very different doctrine than the one that existed before, and it's essentially worthless and toothless, so don't even worry about it anymore. In fact, he, I think, essentially encourages and outright calls for judges, lower court judges, to ignore Auer Deference and find ways to evade it. So quite pointed. I'll just move quickly through these last couple slides, and then we'll wrap up and take any questions. But the Gorsuch opinion essentially lays out an argument that says, again, that the doctrine, when it was first adopted all the way back in Seminole Rock, was never understood in the way that it's been applied in more recent years, that it's essentially been expanded and morphed over time into to mean something quite different than what Seminole Rock actually said. And he believes that it violates the separation of powers because you allow agencies to adopt their own vague regulations and then essentially reserve for themselves the power to be the judge of what that regulation means. And then therefore, you're not giving parties proper notice about what a regulation means, and you're encouraging vague rules instead. And he doesn't believe, again, that stare decisis warrants retaining this, particularly after he says the majority has changed it so much from how it's been applied, and kind of they've narrowed it so much that it isn't even the same doctrine, so you might as well just overrule it. I will quickly wrap up here and then ask my colleagues, Artine and Nicole, to offer any closing observations. But again, I think the important thing to take away from this term is that these deference doctrines from courts deferring to agencies, they're under attack, the battle is not over, and that conservative justices are especially and expressly calling on lower courts to evade these doctrines and apply the law the way they believe it is best interpreted. Chief Justice Roberts was more concerned about stare decisis and preserving the appearance of a nonpartisan court, which clearly frustrated the other conservative justices. This leads to new lines of attack and argument that are likely to emerge in TCPA cases, and that is not necessarily, let me be clear, a good thing, because those lines of attack will be from both plaintiffs and defendants and may in fact cause litigation to become even more uncertain than it already is. With that, I think obviously we'll continue to monitor these issues and the cases as they get taken up for further consideration. But let me call on Artine and Nicole to offer any other closing insights they would like.
Thank you, David. So as I was reading these two pairs of Supreme Court cases, sort of my thought and my takeaways was that the court seems to be giving leeway, or at the very least providing some paths for lower courts to potentially reject agency interpretation. As David and Artine mentioned, in the PDR case, Kavanaugh's concurring opinion in essence provided a roadmap for litigants and lower courts to challenge deference to agencies. And in the Kisor case, the court declined to overrule Auer, but the court clearly was refocusing on the limits of Auer deference. And the opinion set forth some principles to follow which further limited Auer deference, which means maybe going forward that courts might be less likely to give deference to agencies. I think it still remains to be seen how all this will play out, but I think one thing is clear is that the deference doctrine are definitely under scrutiny.
Thanks, Nicole, for those insights. That was great. I'm going to go ahead.
Artine, let me jump in just before you give your closing comments. Let me remind those that are listening that if they have questions, now would be a great time to submit those questions. And after Artine gives us his closing thoughts, we'll try to address anything that's pending. Sorry for the interruption. Go ahead.
Not to worry. So from my perspective is from kind of the in-the-trenches litigator handling individual and class action TCPA claims, and all at the same time consulting with all manner of businesses on compliance, right? How do we follow the law? What's the law? How do we operationalize all of these different rules and regulations around the TCPA? And so the way that I look at this potential erosion in deference is that ultimately, it's hard to say if it's going to be a good or bad thing, because I believe it is inherently a double-edged sword, because the less deference you're giving to FCC rulings means that you're going to have less certainty and uniformity in the rules that businesses need to follow to stay in compliance with the TCPA. And so I think a great example of what could happen here, if, say, for instance, the viewpoint that the Hobbs Act compels lower courts to essentially blindly, I'm using that term a little loosely, follow FCC orders, is illustrated by what's happening in the courts right now in the wake of the D.C. Circuit's opinion in ACA International versus FCC. Now there, the issue is about the validity versus binding effect of FCC orders, but nonetheless, many courts have found that that rule wiped the slate clean on prior FCC orders pertaining to the definition of automatic telephone dialing system. And what we've seen as that's percolated through the lower courts is a heck of a lot of inconsistency on where courts end up on the question of the functions a device has to perform. So really we're getting quite a lot of jurisdictional judge-by-judge variance on this point, which makes it difficult to say exactly kind of where the boundaries of the law lie, because there is so much variance in how courts have addressed these issues in the absence of binding or clear FCC guidance. So we might see the same thing if, in fact, this drumbeat of eroding deference doctrine marches on and really kind of results in a change of the landscape in this fashion. Now, there's a number of legal developments that's been driven by FCC rulings with respect to the TCPA. That's not only for instance, the definition of an automatic telephone dialing system, how you treat wrong number calls, what's the definition of a called party, and importantly, if, say, hypothetically, courts were not necessarily bound to follow all these prior FCC rules, and that would put things in limbo potentially, like the FCC's bedrock rule surrounding prior express consent in the context of debt collection. That right there is a product, the rule that consent is established if a consumer voluntarily provides their phone number without anything more. That is a FCC-created appendage to the prior express consent rules that may be subject to challenge itself if deference is ultimately eroded to the point where litigants are free to make as-applied challenges to the enforceability of prior FCC rulings. So it's not going to be a have your cake and eat it too kind of outcome here. There's going to be both good and bad that might ultimately result depending on how this all shakes out in the courts. And from honestly an intellectual standpoint, aside from these kind of practical considerations, this has been an incredibly interesting Supreme Court term, and it's very remarkable to see how one single fax kind of triggered this showdown in the high court over these agency doctrine. I don't think that PDR, when it was sending out these fax messages, could have ever imagined that this is what it would ultimately lead to in the highest court of the land. So very, very interesting Supreme Court term. We'll obviously be paying very close attention to how this all plays out when it goes back down to the Fourth Circuit and amongst the lower courts as well. So thank you very much.
Great. Thank you again to everyone for participating. It doesn't appear that we have any pending questions that have been unanswered. If you do have questions after the webinar, feel free to email any of us on the presentation today. And thank you so much for participating. Have a great day, everyone.